Well, once more, Chief Justice John Roberts has sided with the majority of U.S. Supreme Court justices to smother the original meaning of the very document that created the Supreme Court itself. And this time, it's even worse than his previous alliances with leftists, because the majority was composed of so-called conservatives. And the ruling has left standing Massachusetts Senator Liz Warren's Orwellian Consumer Financial Protection Bureau, which bears about as much resemblance to anything protective or constitutional as Liz's DNA test does to her claims of American Indian heritage. Well, comrades, the ruling has supposedly upset leftists in America because, as a New York Magazine Intelligencer headline proclaims, the Supreme Court restricts independence of CFPB, but doesn't kill it. But in fact, the ruling should upset anyone who asks politicians and judges in D.C., who loudly, proudly swear oaths that they will do so, that they actually uphold and abide by the Constitution that created their offices. In question Monday, in a case called CELO Law LLC v. Consumer Financial Protection Bureau, was whether any president has the power to remove the head of the Obama-era Consumer Financial Protection Bureau, a bureau ostensibly created to consolidate other regulatory agencies dealing with banks, investment companies, and lending institutions, and agencies that often hand out money and special favors like deposit insurance to the very entities that they're supposedly regulating. Now, many leftists claim that the so-called independence of the Bureau was at stake because, well, heck, if a president can remove the head of the agency, then that head might toe the president's line, and the agency might become politicized.
I'm independent.
Yeah? Me too. I'm whatever you said. Independent.
Meanwhile, clear-headed folks note that anything associated with the polis is, by definition, political, and that the CFPB is a federal creation, which means that there's only one branch of the U.S. government that can execute the 2010 statute that created the thing, and that would be the executive branch.
That was the number one answer.
And this, in a roundabout way, is what the majority ruled on Monday, allowing for a president to remove the head of the Bureau. But, as is typical, in doing so, they kept standing a number of unconstitutional practices. Statutes, in fact, including the statute that created the clearly unconstitutional CFPB itself. And they left standing previous erroneous rulings, and we're going to get into it. As Damon Root reports for Reason Magazine, to reach that conclusion in Monday's CELO Law decision, the Chief Justice had to first grapple with Humphrey Executor v. United States from 1935, a far-reaching New Deal-era case in which the Supreme Court ruled unanimously that President Franklin Roosevelt lacked the authority to fire a commissioner of the Federal Trade Commission, FTC, over political differences. You read that right. But just to demonstrate how little regard for the Constitution and logic that 1935 and by its deference to precedent today's Supreme Court majority displayed and display, here is more via Mr. Root. The FTC, quote, must, from the very nature of its duties, act with entire impartiality, end quote, wrote Justice George Sutherland. Quote, it is charged with the enforcement of no policy except the policy of the law, end quote. Sorry. Because it, quote, cannot in any proper sense be characterized as an arm or an eye of the executive, end quote, Sutherland concluded. The agency, quote, must be free from executive control, end quote. When do they have civics classes? Like in 6th grade or something like that? Like the 3 branches, executive? Did this guy skip those classes? I don't know. But anyway, Getting back to it. Which not only smacks headlong against the founders' rule of the executive branch actually executing constitutionally sound statutes that the legislative branch passes, it runs afoul of basic logic. If there are only 3 federal government branches and the executive branch, supposedly tasked with executing statutes, does not have control over a federally created bureau, who then has control? And how, therefore, could the legislation allowing for that bureau have been executed in the first place? The FDR-era court never addressed that. In fact, they conjured out of thin air the idea that there could be some magical other arm of DC power, a new dimension of federal bureaucracy that can be created by federal legislation and put into operation by the executive branch, but then could act on its own.
You unlock this door with the key of imagination. Beyond it is another dimension. A dimension of sound. A dimension of sight. A dimension of mind.
And in this way, the 1935 Supreme Court allowed for the continuation of the unconstitutional Federal Trade Commission and prevented a president from pulling members of its 5-member Board of Commissioners. So, the media focus Monday has been on the shocking variation in how Justice Roberts and the evil, supposedly conservative majority differently view the FTC board and the lone CFPB director. It's a distinction leftist supporters of the CFPB monstrously imply that the conservatives drew in order to give Donald Trump power to weaken this important Consumer Protection Bureau. And it's a distinction that comes from the conservatives finding that one director in charge of the CFPB gives that person too much power without some kind of chief executive check. Well, shoot, isn't that sweet of them to actually decide for everyone? Writes Root. The answer lies in part in the fact that the FTC is run by a panel of 5 commissioners, and according to federal law, quote, not more than 3 of the commissioners shall be members of the same political party, end quote. The director of the CFPB, by contrast, does not share power with any such panel and is not subject to any such political constraints. And offered Roberts in the conclusion of his majority decision, in our constitutional system, the executive power belongs to the president, and that power generally includes the ability to supervise and remove the agents who wield executive power in his stead. While we have previously, and we, he means the old Supreme Court, upheld limits on the president's removal authority in certain contexts, we decline to do so when it comes to principal officers who, acting alone, wield significant executive power. The Constitution requires that such officials remain dependent on the president, who in turn is accountable to the people. Right. He's so accountable to the people. Oh, man. Oh. It's like Red Dwarf when Lister's trying to tell Crichton that a banana is an orange. And Crichton's like, no, it's a banana. No matter how many times they say it, it's still a banana. They can't keep saying, oh, accountable to the people. God. Okay. Which sounds nice, but is internally inconsistent and doesn't jibe with the Constitution in any way. Simply put, as Americans of the founding era understood, the Constitution vests the president with the executive power, and he swears an oath to protect and defend the Constitution. The Constitution requires him to execute constitutional laws. But the president's oath mandates that he not execute unconstitutional laws. He has a sworn duty not to. And one of the ways he can do this is to not fund executive branch agencies created by congressional legislation. Now, contemporary Americans might remember part of this because they saw a vestige of it when George W. Bush included so-called signing statements upon putting his tax-funded pen to certain laws. He was saying that he would exercise his executive branch prerogative to not execute certain laws or aspects of them, and also, unfortunately, in his case, to continue operating in certain unconstitutional ways himself. Which leads us back to the Monday Selah Law ruling and the important conclusions. The key to this is that Justice Roberts and the majority did not address the most fundamental point, which is whether, like the FTC and all other regulatory agencies, there's any provision in the Constitution allowing for the bodies to exist at all. As NPR actually notes, but the court did not go as far as the challengers had wanted, limiting the decision to the single director structure of the CFPB. Roberts wrote, quote, "The CFPB director's removal protection is severable from the other statutory provisions bearing on the CFPB's authority. The agency may therefore continue to operate, but its director, in light of our decision, must be removable by the president at will." Well, while some Trump boosters might applaud, this is a classic dodge and something that Justices Thomas and Gorsuch, although concurring with the determination that the chief executive has the power to remove a bureau director within the executive branch, addressed separately this point to express their dissent. There's a great deal to read in this partial dissent that they wrote, so I recommend it to anybody. But at the opening, they hint at the most fundamental of issues. Quote, "The decision in Humphrey's Executor, 1935, poses a direct threat to our constitutional structure and, as a result, the liberty of the American people." Folks, the issue is not merely whether the president has control over executive branch agencies. The issue is whether the Constitution allows for their creation in the first place. And the answer to that is clearly no. The creation of these bureaus rests on what I've noted many times when writing on federal regulation, and that is a misreading of the Interstate Commerce Clause in Article 1, Section 8 of the Constitution. As I often stress, James Madison himself stated that to view the clause as granting power to, quote, regulate, end quote, anything that goes over state borders, including transactions in the financial sector, is to invent a power that the founders never intended. And of course, I don't think we can ever hope that the Supreme Court or anyone in D.C. or even in most state or local governments will ever show the courage to actually admit that and read what James Madison warned us about so many years ago. Well, we're seeing it play out in front of us almost every year, almost every day, with new regulations and new agencies that pop up every few years, supposedly to protect us even as they eat away at our liberty.
That was the number one answer.